Hello everyone, and welcome back to Informapedia, your go-to series for breaking down complex news into bite-sized knowledge. I'm your host, Akoni, and this is episode 25. Today, we're diving into a landmark Supreme Court judgment from August 5th, 2025 that's shaking up India's environmental rules for big construction projects. If you've ever wondered how buildings and townships get the green light without harming nature, stick around. We've got the simple scoop. Let's start with the basics. Back in 2006, India introduced the EIA notification, that's Environmental Impact Assessment, to ensure big projects don't wreck the environment. For construction stuff like apartments, offices under Schedule 8A, and massive townships 8B, you need environmental clearance before digging starts. This checks for pollution, wildlife impact, and more. But here's the drama. On January 29, 2025, the Environment Ministry issued a new notification tweaking these rules. An NGO called Vanashakti challenged it, saying it weakens protections, especially for projects near sensitive areas like national parks. The petitioners argued this new rule ignores past court smackdowns on similar dilutions from 2014, 2016, and 2018. They wanted the Supreme Court to hit pause to avoid conflicting decisions. Now, what did the Supreme Court say? In a nutshell, they mostly upheld the 2025 changes, but with a crucial twist. First, the good news for builders. The court clarified that these construction projects never needed central government approval under the original 2006 rules, even if near eco-sensitive zones. The 2025 notification just makes it super clear, so states' expert bodies called SEIAA can handle approvals, speeding things up. No more central bottlenecks. Why? The court looked at the fine print. The 2006 schedule doesn't apply general conditions like central oversight for sensitive areas to 8A and 8B projects. It's always been state level. But wait, the court didn't let everything slide. They quashed one sneaky part. The new rule tried to exempt big industrial sheds, schools, colleges, and hostels from any clearance, as long as they do basic green stuff like rainwater harvesting. The judges called this arbitrary. Why? A massive school or factory over 20,000 square meters can still pollute or harm habitats. No free pass. All big builds must get checked. Education's big business these days, folks. No exemptions. They also upheld a follow-up memo from January 30th, 2025, applying these rules to Kerala too. That's a win for uniform environmental protection. Overall repercussions. For the EIA 2006 and its amendments, no more confusion. States approve faster but with expert checks. Over 700 stalled projects in Maharashtra alone can now move. Stronger safeguards. No exemptions mean more projects face scrutiny, balancing growth with nature. Future tweaks. Governments can't dilute rules willy-nilly. Courts will ensure sustainable development progress without trashing the planet. This judgment reminds us, development is key for India's growth, but we hold nature in trust for our kids. If you're a builder, expect state green nods, no shortcuts. For the rest of us, it's a step toward greener cities. That's a wrap on episode 25. If you learned something, hit like, subscribe, and drop a comment. What environmental issue should we cover next? I'm Akoni, signing off from Informapedia. Stay informed, stay green.